Okay, I will be calling the Newburgh Dundee Public School Board meeting into session for July 24th, 2024 work session. And Director Hayden has a comment.
Yeah, before we do a flag salute, we are aware that there is a YouTube issue for the school district. We think we understand what needs to happen. Tonight's meeting, if you know people are wanting to join, you should just direct them or notify them to get on the Zoom link and not try to follow it via YouTube Live. We will update the recording, or we'll upload the recording once we have it available from Zoom, but this meeting is being recorded via Zoom right now.
Well, thank you very much. Okay, so we'll start with the flag salute. Ms. Nichols, Director Nichols, would you like to do that? All right, we're pleased to have, the action item, sorry. I thought we were going into the OGEC training. All right, so Dr. Radich, you want to talk about the surplus for Tiger manufacturing equipment? We don't have a quorum. Is there a way to tell if we have? Okay, I don't think we have a quorum to be able to.
We'll just postpone this item until we have a quorum August 13th.
Okay, perfect. Thank you. So then we will just go right into our Oregon government ethics training, and I am going to turn it over to the fine folks from OGEC.
Go. Awesome. Okay. Well, my name's Charlie. As far as I'm with the Oregon Government Ethics Commission, Lex Tingy is here today, and we're both giving you the trainings for the Oregon Government Ethics Commission. Today, it's all going to be about executive session. Okay, so not as long a training as last week. This one's all going to be about when you're going from public meeting into executive session, which is part of public meetings law. Okay, I'm sure you folks already know that we are working on a public meetings law curriculum. That's where it's in the works. We're hoping to roll it out sometime in the fall. We try to think positive, but we've been pushing this thing back for a while now, but we're on track. So it is being worked on. The thing is that we also have to get approval for the Department of Justice to make sure that we're giving the right information to you folks. So it's not just us. We also have to get approval for the material that we present to you folks. So yeah.
Oh, it's an intended.
There we go.
I'll send her the email again, but she should be at a panelist, not attendee. There's no way to add the attendees.
Well, you said, wasn't there a button to say allowed to talk?
Was there?
Should be saying this on the speaker.
That's Ron Woodward.
Woodward.
Yeah.
Nancy Woodward.
Okay.
There.
Hey, all right. We can
You have a quorum now.
right on. Okay, well let's keep rolling. Are y'all good with that?
Yeah, we'll just keep going. Thank you.
Okay. All right. So I do have let's see, hang on, my little clicker. Oh, there it goes. Okay, hang on. So just like last time, heads up, I have polling clickers for you folks. So we're going to do polling again in this session. Just make sure that it doesn't have the test screen and all that to do the vanilla and chocolate ice cream. We're just going to go straight into the polling. So, so let me explain something here with executive session. When it comes to public meetings law, what we're talking about here is the Oregon government believes in transparency and also allowing the public to be a part of those meetings. Okay. And the, what the actual final decisions and how we came to those decisions are made in public meetings. The executive session provisions talk about when you could actually go into private and talk about, discuss some things that the public is not allowed, okay? Let me clarify something here, that even though you go into executive session, you always make your final decision on any topic in public session, okay? So you can go into executive session and reach consensus, reach an agreement, but you make that final action in public meetings law, or in public meeting, okay? Everybody with me so far? All right, you're gonna hear me say that a lot because it's in this presentation quite a bit, so you know that's kind of what we're stressing. And so all these provisions are found in ORS 192660, okay, which is a portion of public meetings law, okay? And so Lex handed out some stuff to help guide you through that. We have a little cheat sheet to help you with that as well. So I just kind of want to get in your mind that when you go into executive session, we're going to talk about the criteria that you have to meet to in order to go into executive session and make sure that it's legal. All right, so today's objectives, we're going to identify your responsibilities regarding executive session. We're going to select the steps to convene an executive session, which is going to fall under the making that announcement and making sure that it's public and it's posted. And then, oh, I'm clicking too fast. Your clicker works too good. All right, then the last part is going to be the allowable reasons for you to go into executive session. And basically what that means is when you go into executive session, you can only talk about certain things. It's not a free for all. It is, you can talk about these things and these things only, okay? All right, so a little bit about the Ethics Commission. I know y'all have heard this already before, but we were created in 1974. And again, it was an attempt to restore public trust in government, okay? And so statutes behind that, you know, you folks already know the ethics stuff lies in ORS 244, Executive Session 192. We also have some in 1774 lobby law. But we do have a 9-member citizen commission. So there's the agency itself, and then there's the commission, which is the 9 members that oversee us. And so we don't ever make decisions on our own. We always go to the commissioners to tell us how to move forward on something. So, all right. So here's our jurisdiction. I mentioned already the ethics law, which we covered last week, all ORS 244. Lobby law is in 171. I said 177, 171. And then public meetings is going to be 192. Oh, all right. So let me also throw this out here. We don't see it in this presentation, but today again is going to be a broad overview. So we're not going to get into all the finite parts of the statute. So that being said, this is not legal advice, okay? But you already know what are we if you have a question or concern. We're a resource. So do not hesitate to reach out to us and contact us. We are more than happy to help you with this. So we're more than happy to find out that folks are calling us and asking questions. That's kind of what we do. So, all right. So get your clickers ready. I think we're gonna have a few less this time than last time. So what's the magic number today? Is it 4? 4 people?
Well, yeah, Paula has.
Just makes it 4 with Paula. Are you voting? Are you going to go? Okay, so it's 3 because Nancy isn't able to do the voting
Yeah.
from.
So this is all for fun. There's no grade. It's anonymous. You guys already been through this before. So, you know, the quicker you respond, the quicker the meeting goes along here. So quicker the training goes. So let's see what you know. And we're gonna revisit this again as we go through the training. So the first one is, if the discussion topic meets the requirements for being discussed in executive session, the governing body cannot meet in open session to discuss the topic. Okay, let me reword this for you. If it's allowed to be talked about in executive session, can you talk about it in public meeting? That's what it's asking. True or false? What do you think? You can totally guess. You already know at this point, there's no right or wrong. We are holding out for number 3 right now.
Oh, sorry. I was just kidding.
I was gonna say, is there a C? It depends.
That's not a trick question. You guys already know that what you see here, we're going to talk about. So, all right. Let's go to the next one. All right. If the public body will be discussing multiple topics in executive session, all right, A, 192660 needs to be cited. However, no specific reasons or statutes need to be announced. Or B, only one of the topics must be announced before entering executive session. C, all the topics that will be discussed in executive session must be cited. Or D, topics only need to be cited in the public notice and do not need to be cited again before entering executive session. Oh, we got 3 already. I'm over here daydreaming. All right. The governing body can make a final decision in executive session, true or false? I think y'all know the answer to that one already. All right. During a meeting, members of a governing body are individually and independently responsible for A, their actions, B, their non-actions, C, their actions and their non-actions, or D, nothing. The governing body is responsible. All right, topics discussed in executive session must be expressly permitted by the statutory provisions and properly cited. The discussion may not cover other topics, even if those topics are related to the topic cited. True or false? All right, before a governing body may convene an executive session to consider the employment of a public officer, a staff member, or individual agent, the following prerequisites must be met. So A, advertise the vacancy. B, adopt regular hiring procedures. C, provide an opportunity for the public comment on the officer's employment. D, for a chief executive officer, adopt hiring standards, criteria, and policy directives in meetings open to the public where the public can comment. E, all the above, or F, none of the above.
I'm sorry, I don't know what I was doing. I was daydreaming myself. What's the statement or the question that what are
What are
Yeah.
the prerequisites in considering the employment of a public official or staff member?
Okay.
You might need to go back, show the polling is closed. Yeah, mine's not going.
Okay, let me go back.
You have the incorrect answer. Just tell me you're wrong.
All right, did you reset it? It is.
Yeah.
Okay. All right, so let's go over it again. That's us, that's our software doing its thing
Yeah.
on our end.
Wasn't you?
All right, so before a governing body may convene an executive session to consider the employment of a public officer, staff member, or individual agent, the following prerequisites must be met. Let's try this again. All right, there we go. Advertise the vacancy, adopt regular hiring procedures, provide an opportunity for public comment on the officer's employment. For a CEO, adopt hiring standards, criteria, policy directives and meetings open to the public where the public can comment. E, all the above, or F, none of the above. All right, so definitions. All right, so we always start the trainings with definitions because they're going to come up again and again throughout the presentation. So the first one is going to be a public body. And so a public body, kind of the short answer of this is if it's a state agency, a county, a city, a special district, or any type of agency that is required or meets the statutes for Oregon law as a public body. Okay, so you're probably wondering, hang on, let me back up. So state government, public body, local government, public body, special government bodies, school district, public body. Okay, so you're going to see that come up. When you see the word public body, that's what we're talking about. Okay, so the governing body. So these are the folks that that have the decision-making capabilities for that public body. Okay, so this is going to be, this could be a committee, it could be a board, it can be a commission, it could be an advisory board. These are the folks that have the authority to make decisions for that public body. Okay, so let me clarify something. One person is not the governing body. Okay, so it's going to be 2 or more people. All right, so convening. So this is where you folks actually will meet. And so how they define convening is when you're gathering in a physical location. So right now we're convening, okay? But it's not just a physical location, okay? It can also be using technology to communicate in real time. That's just a fancy way of saying it can be in a Teams meeting, it can be in a Zoom meeting, it can be over the phone. You can convene that way as well. And so this is where we get into serial electronic written communication. So that's another fancy way of saying maybe you folks are messaging each other. You know, you're all included on an email chain and you're all stating things in these emails and having discussions, and that's considered convening as well. And then this is where intermediary to communicate. This is where you have another party in between you folks that's doing the communicating between the both of y'all. Okay. So everybody with me so far?
Can you elaborate on the last one?
I will try, because this is a new part of the slide that I was like okay. all right.
Uh-oh.
Because convening came up in public meetings law. This wasn't something that we discussed in executive session.
And I will interject that some of these we are still defining with making rules for public meetings law, so we may not have some extra definitions.
We're still waiting on
But it would
the,
be like using a secretary to send an email, send a message to someone. That would be using an intermediary to send a message. Does that kind of help a little bit?
To send a message, or just to say, here's information that I want the board to read. We're not asking for feedback. We're not asking for, responses, just to share.
okay, so when we're talking about convening, and I may be stepping things out a little bit, is this is where we're talking about the governing body having conversations with each other, which is, it parallels meeting. Okay, that's going to be the next definition coming out. Okay, but this is not going to be just asking for status of something or information or scheduling, things like that. That's not part of this. So that wouldn't be part of the intermediary communication. You tell I'm new at this one. Does that help you at all?
I believe so, yes.
Okay.
So,
This sounds like, you know what this is? This is going to be a follow-up.
Yeah, I was gonna say, I do think you need that back and forth for it to be considered a convening in this, but we would want to follow up and probably wait until the rules are defined to be 100% sure on that. We can definitely follow up on that.
Okay. I was nervous about that one. I was
Yeah.
like, all the new slides, I'm like, oh man. All right, so and this is where we get into public meetings law where this doesn't count. Okay, so if you're just asking for information, then that doesn't fall under public meetings law. If you're asking for unrelated to the governing body's deliberation or decisions, if you're just asking about information, wanting to know the status of something, this is not part of public meetings law. And the last part here is if it's non-substantive. So if you're talking about scheduling, where you're going to have that next meeting at, that's not part of public meetings law. Okay. So we start getting public meetings law. We're really talking about, we're here to make some decisions. We're here to convene and talk about some things and make some decisions. So, which is going to bring me to my next definition, which is meeting. Okay. So we're talking about a meeting. We're talking about the folks of the governing body of that public body are meeting to make a decision. Okay. So making a vote, a recommendation, or just have communication about a decision they may be making. Okay. So that's what a meeting is. So a meeting, however, is not an on-site inspection. This back and forth between someone else saying, well, hey, where are you going for lunch? We're going here. That's not part of a meeting. This is, again, a meeting is defined as you folks coming together to make a decision. Okay. All right. Which comes to our next definition, which is a decision. And so this is where you're making a determination, an action, a vote, a final disposition on a motion, a proposal, resolution, order, ordinance, or measure. And so what do y'all know about that final decision? Where is that final decision made? In public meetings. It's not in executive session. So remember, in executive session, again, I'm hammering this because this is something, it's in our trainings many times because this is things we run into. So just remember that in executive session, you're allowed to have a general consensus. Y'all can all agree on what the next step's going to be. That final vote, that final decision is made in open session or in public meeting. All right. And so deliberation, this to me parallels convening, but this is when you folks are discussing, having communications, and part of that decision-making process. All right, so executive session. So what is executive session exactly? Okay, so again, Oregon believes in an open government. And again, the public has the right to know what decisions are being made, what materials are put forward to make these decisions. However, executive session is a part of public meetings where you're allowed to close the doors, where the public is not allowed. Okay, and so we're going to see all these things that allow you to go into executive session when Lex steps up. Okay, so it's very defined for what you can go into executive session for. All right. So responsibility. I'm fixing to hand it off to you here in a sec. So when it comes to following the rules, you know this already because we talked about it in RS 244. But when it comes to responsibility of the executive session and how this all unfolds is up to the individual. Okay, so you can't ever say, or as far as the Ethics Commission is concerned, we don't look at, well, the whole governing body was doing it wrong, so we're all guilty. The whole school district is wrong. We look at the individual. So when it comes to responsibility to all the ethics law, it always comes back to the individual. So you probably saw that hint there. You know, we are responsible for our actions. Okay, also our inactions. So we'll see some of that as we roll through this. So who is responsible? Members of the governing body. So that would be you folks. Every individual is responsible for their actions and non-actions. And then if there is an issue with someone not following the statutes correctly, then fines are issued to the person's individual. Okay, so let me throw a scenario at you because I don't know if it's in later on in this presentation, but a good example is if y'all are in executive session and you already know that you can't veer off topic. Okay, so you have to stay on topic when executive session, even if topics are related. Okay, so just let me give you an example of that. So let's say you're talking about, again, building a new wing to the school. Okay, and while you're in that discussion, you start discussing, well, you know what, we need a maintenance building too. So let's go ahead and start talking about what we're going to do with the maintenance building. Okay, so now you are off topic. Okay, so you know the conversation has gone off topic. What do? So as you as a public official, knowing what you know after this training, you'll be able to go, hang on, per the agenda for what we cited going into executive session was for that new wing of the building. A new maintenance building was not part of this discussion today. So we need to stop that conversation and get back to the conversation at hand to the new school wing. Okay. All right. So you've done your due diligence, right? Okay. But let's just say it keeps going. Still talking about the maintenance building. What do you do at that point? Well, you as an individual are responsible for your actions and inactions, right? So at this point, what you would want to do is step up and say, this topic has gone off meeting. This meeting has gone off topic. We are now not following executive session any longer. So at this point, I'm noting for the record that I'm leaving this discussion at this point. Okay. And here's the catch. Actually have to leave discussion. You have to get up and leave. Okay. Because if you sit in here during that discussion, everyone keeps going. Guess what? Everyone's in violation of that executive session. But you have to state for the record, you actually have to leave, because if you don't leave, guess what? You're still part of that discussion. Okay. So that's what we're talking about when it comes to your actions, your inactions. You want to make sure that you're following through with that. Okay. Everybody with me so far? Awesome. Okay. I know I say that a lot. Y'all probably like, oh, here it is.
I was trying to tell you to click.
So I thought you were like going, yeah, you got it. So yeah, there you go. State your objection to discussion. And then announce on record that you're leaving. Okay. And I can't stress this enough, but you actually have to leave. Okay. We've had some folks that have told us, I stated that it was off topic and I'm leaving the discussion, but I stayed in there because I just wanted to make sure things I wanted to see how far I was going to go off the rails. No, you got to get up and all right. And there it says, leave the session. All right. So now we're going to get into entering executive session. I'm going to hand it over to Lex. She's awesome, by the way. So
I'm just going to sit here to make sure everyone can hear me through a mask. So
All right, so for entering executive session, one of the resources we really recommend is the Attorney General's Manual. It not only has FAQ, so if you do have any questions, but it has a checklist on how to enter executive session, as well as some sample scripts. So it's something we have linked on our website, but we use it for our commissioners as well, so it's something we recommend. But this is an example of the checklist you should be going through when entering into executive session, excuse me. So prior to the meeting, you want to provide notice, similar to what you would do for a public meeting, just making sure you're noticing why you're going into executive session, what provisions. Like we mentioned earlier, if you're going in for multiple executive session provisions, make sure each one is mentioned. You can't just mention all of 192.660. You have to mention the specific subsections. So that one's going to be pretty easy. We also recommend letting everyone on the board look at it to make sure, because again, individually responsible. So if someone notices, hey, we forgot to mention this subsection, you can notice it ahead of time and fix that. Once you're at the meeting, that's when you're going to have the most things to pay attention to. So of course, you're going to then announce the reasons for going into executive session. Again, if there's multiple, make sure you're listing all of them. And then you'll also, yes.
Do you have to read the entire statement, or can you just say ORS 192.66?
So we do,
2B.
we do recommend that you read the entire statement for
Okay.
the reason you're going into, just because again, Oregon government, we want the public to be aware. They may not know what that statute means.
Okay.
So to be totally safe, you should say, we're going into 192.660 subsection 4 to discuss this matter. So that's a really good question. And then you'll also say if you're coming back into open session, something to be aware of here, if you do list that, hey, we're coming back into open session at 1 p.m., if you list a time, even if you get done early, you do have to come back at 1 p.m. You have to wait until that listed time. If you don't list the time and just say we'll be coming back into open session afterwards, you can just come back into open session. If you say you're not coming back into open session, and then turns out during executive session, you realize, oh no, we have to make a final decision. We know we can't do this. We have to have a public session. You will either have to wait until your next public session to do so, or you can try to say, make reasonable notice to notice everyone that you're about to go into public session. That's obviously going to be hard to do because you'd want to make sure interested parties got notice, the general public got notice. That can be hard to do, so it's probably best to wait until the next open session, but just some things to be aware of with that checklist item. The next thing, obviously, with executive session, most of the time, media is allowed to remain. There are some sections that allow them to be disbarred or to be barred from it. We'll talk about that. But then there are some, the chair, excuse me, or presiding authority can decide to let other individuals remain in executive session depending on what's being talked about. So that's the point you can announce that. And then you'll also want to announce if there's any matters exempt from disclosure. So if there's anything you don't want to be shared about during executive session, that's when you would mention that. After you've done all that, you can finally go into executive session, talk, do everything you need to do. And just again, remembering no final decisions. Again, like Charlie was saying, you can come to a consensus. You can know that we're pretty aware everyone's going to vote this way, but you cannot take that final vote until you're in open session. And so that's everything to do during executive session. And then after the meeting, just making sure you keep records. So whether that's minutes of the executive session itself or video recording, that's fine. You do not have to share those. You do just have to have those saved. For example, if there was ever a complaint submitted or something, that is something our investigators would be looking at to see if things were followed. And that's just a statutory requirement to have minutes of your executive session.
I have a question about the minutes.
Mhm.
Oops, sorry. Is there a minimum amount of information that needs to be recorded?
That is a really good question. So this is actually one of the rules that we are working on for public meetings law right now. There isn't a specific minimum. It just says that they have to state the true nature of the discussion. I can follow up with that to double check how they're written right now.
Yeah, if you have even a couple examples we could look at,
Mhm.
because I'll be taking minutes tonight and I want to be sure I did
Yeah.
it correctly. Okay.
No, definitely. I can look and
Thank you.
see. For example, for our executive session, because with the commission, we're a little bit different. We are obligated to actually share the recordings of our executive session after. We just do video, so we just video everything and have it. For the minutes itself, Again, it doesn't say you have to keep a minimum amount. It just has to keep the true record. That might be something we need to look at clarifying in the rules further. That could be a comment, but we'll definitely follow up on that. So the AG manual has that checklist, and then this is the sample script. It also has, like I said, it's really great because it not only helps you make sure that you're listing the reason you're going into, but also hitting when you're coming back into open session, if the media who's allowed to attend, anyone else that's allowed to attend, and if there's anything they need to not be disclosed from executive session. So makes it a lot easier when you have a mouthful of words to remember. So yes.
I have a question about the returning to open session. So in my short experience here, most of the time we do our executive session and then we have, interested public members that are waiting very patiently. And so we try to update the approximate time. It says approximately, and then that time gets updated periodically while we are still in executive session. Is that practice okay? Or should we just, I want to balance, it would be fine to just say, we'll come into open session when we're done, but then
that gives some
that
time.
doesn't put into the consideration the people that are waiting so patiently for us.
Because you're using the word approximately, I think you're okay, but I will definitely follow up on that with our the director to make sure. Yeah, that's a good question.
Thank
So,
you.
Well, but the agenda says followed by executive session.
yeah, does the agenda list it? So the agenda doesn't list the time, it's just your
No.
updates.
It's just usually on the Zoom.
Okay. So I think because your agenda isn't listing the time and you were just updating on Zoom, I think that would be okay. I will double check with our executive director to make sure for you. But yeah, because you're not listing a time on the agenda and that's being noticed to the public,
Perfect.
I think
Okay.
you'd be fine. It's when you're noticing to the public, yes, we are going to open session at 1 p.m.
Perfect.
Then you have to stick to that.
Okay.
So
Thank you.
of course.
I know that, I'm sorry, I know that script is a sample script. Is there, ours is pretty close, but we're missing the last line, the asterisk one, the governing body. Should we, does that need it?
That is just on the script to let you know that if there is anyone else you are choosing to allow, that is okay. That is your right. The governing body can allow other people to attend executive session.
Right, and we're listing out the media reasons why they should be excluded, or
Mhm.
why
Yeah.
media should be excluded. Yeah.
Yes. Mhm.
Yep.
Perfect. And then, of course, we've mentioned this a few times. You're probably tired of hearing it, but no final decisions in executive session. That is no final actions, no final vote. Again, consensus is fine. You can kind of be aware of what everyone's going to vote. That's fine, but that formal vote, that formal action has to happen in open session because the public has to be aware of what happened. So now we'll kind of talk about some of the reasons. We'll talk about the most common. The worksheet, the little handout I gave does list all of the reasons. We're not going to cover all of them today just because some of them don't get used that often. So we'll just go over the most common, but if you do have any questions, let me know. But first up, we'll talk about the HR kind of related ones. So this is initial employment of public officers, employees, and agents. So keyword here is initial employment. This isn't just like overall employment of anything, initial employment for a position. You are allowed to go into executive session with some prerequisites. So the prerequisites that the vacancy has to have been advertised. Procedures for hiring have been adopted. The public has had a chance to comment if it's a public officer position. And then if it's a chief executive officer position, you had to have adopted hiring standards, criteria, and policy directives. And this has to have happened in a public meeting where the public also had a chance to comment. Yeah.
Is there a certain amount of time frame that we have to, like, the last one, adopting the hiring standards? I mean, can that be like, I don't want to say, probably never the same meeting, like earlier in the day and then the exec session later, but like does that have to be like a week in advance, 30 days in advance to give public notice of that information?
As far as I know, there's no time frame listed within the statutes itself. It's whatever, as long as these have happened before executive session, you're okay.
Okay, thank you.
So, the other thing to remember with this one, because this can get confused a lot of times when we are talking about initial employment executive session, this does not give you the ability to talk about salary or benefits. That is not something that should be discussed in executive session. And that's not something that really should be discussed by governing bodies or public bodies anyways. That's more of a Department of Administrative Services, Human Resources, that kind of thing. So salary should not be discussed in executive session. Something to be aware of. yeah.
Okay, we only have one employee, the
mhm.
superintendent. So when do we discuss it?
So that should be discussed by human resources, not by the public body.
But during the contract where it's going to be
Mhm.
openly talked about, there is talk about the salary. So,
Then it should not be happening in executive session.
okay, but it can be in public.
Yes.
Okay, that's
Mhm.
all I need to know.
Yep.
Okay, thank you.
Yes, the just salary should not be talked about in executive session then, yes. So another HR reason would be discipline and dismissal of public officials. Both the dismissal or disciplining. And this can happen for public officers, employees, staff members, individual agents. Or if you're going to hear complaints or charges brought against such persons, if the person does not request an open hearing. And we're talking about open hearing, we're talking about open session. That's what it's meant. It's not meant like an adversarial hearing. There is a prerequisite here that you have to give them the option to hold that open hearing though. And this has to you have to give them an advance notice, right? You have to give them the ability to actually request that. So you need to provide written notice to them at least 24 hours or 1 business day. It has to name the governing body that's going to be doing this, the time, date, and location of the executive session, the purpose that you're convening an executive session, and then how to request that open hearing if they choose that. And again, open hearing, we mean open session. So the open hearing doesn't mean that they have to be present, that they have the right to hold that up to wait to like request an attorney or anything there. Unless of course they have like a bargaining agreement, contract, or other law that says they have those rights. This statute does not include those. So along those same lines is performance evaluations. So you can review and evaluate the job performance the job performance of chief executive officers, other officers, employees, and staff in executive session if they do not request an open hearing. And same for them, has to be given 24 hours or 1 business day in advance in writing, the name of the governing body, time, date, and location of the meeting, reason for convening, and how to request an open hearing if they would prefer that. So now with performance evaluations, this one can get a little bit tricky because you cannot use that performance evaluation to also talk about evaluation of agency goals. So making sure that any discussion when you're talking about this employee or CEO's performance, that you're not also evaluating agency goals. And then again, we also cannot use this to discuss salary in executive session. So those are 2 lines there.
Just to clarify, agency is us?
Yes.
Okay.
Agency would be the public body as well. Yes.
Thank you.
Yes. I get so used to using that terminology, but yes, that would be the public body as well. So with the HR related ones, to recap, you cannot use any of these to evaluate your public body goals, objectives, operative or directives. You cannot evaluate any directive given to the personnel concerning an agency goal, objective, operative, or program, and then conduct that performance review or discipline without notifying them and allowing them the option to request that open hearing. So those are the 3 main HR ones, probably ones we see the most common for executive session. And then again, making sure not to discuss salary in an executive session. That should probably be added to this slide because that comes up a lot too. But beyond that, labor negotiator. So this is if you're having deliberations with a designated labor negotiator. What it says is what it is. But this is actually one of the ones that media may be excluded from such a session. So this is one that media would not be allowed into executive session. Now, along those lines, also labor consultations. But labor consultations are a little bit different because this is typically an open meeting unless both sides request an executive session. And what's also different with these ones, if both sides do request an executive session, you actually do not have to notice it like you would a typical executive session. So that is also a strange one there. But again, both sides have to request this to be an executive session. Otherwise, it does have to be held in an open meeting. Now, real property transactions. So you're deliberating with a designated person to negotiate a real property transaction. The keyword here is transaction. So a sale some kind of transaction has to be happening. This isn't like we're planning a long-term goal of what we want to do with our property. No, we're actually doing a lease for this term or selling this specific business or this specific land. We can't do long-term goals. It has to be a specific transaction here. That one can be a little confusing. We've seen some people misuse that one. So
a question. So let's just say an entity has an interest in purchasing some property that the district owns. I would assume that discussion could occur in executive session?
Yeah, it would be, because it's transaction, you're looking at a property that's going to be sold.
So as
then-
long as there is a potential for a transaction.
Yes.
That's,
Mhm.
then.
Yeah,
Thank
it would just be if it's, oh, we know we eventually want to sell this. We're not sure who we're going to sell it to. We need to start looking for buyers. That would be a little bit different. So,
If it's tied to an address.
Yes.
The specific address is what we're talking about in here today. We're talking about buying it, leasing it, selling it, then you're in a transaction. Thank you.
and along with that is trade negotiations. So if you want to consider preliminary negotiations involving matters of trade or commerce, if you're competing with other governing bodies in other states or nations. Keywords here are other states or nations, meaning the competing body has to be outside of Oregon. So it can't be competing with another school district in Oregon. It has to be outside of Oregon to go into executive session for this provision.
Could I
So-
go back to
Mhm.
the real property again? So it says must be for deliberations with designee who is negotiating a real property transaction. So sometimes there's more than one person doing that. So it wouldn't have to be like the main person. It could be somebody else who's engaged in that process.
Yeah, so it would be whoever you've designated for that. I mean, it is possible to designate multiple persons.
Okay.
That would be fine,
Okay, thank you.
just as long as they are that entity designated for that, yes. Mhm. And that's something too, like Charlie said before, if there's ever questions with a specific one, honestly, we like the specific situations more because you can call and give us all those details and we can verify all of them. We can definitely say, yes, this falls into that, or actually, no, this doesn't. So you can always call and ask us. So next up is legal counsel. So you are allowed to go into an executive session for consultation with counsel concerning legal rights regarding current litigation or litigation likely to be filed. So this can't happen for litigation that's already occurred. So this is one sometimes we see people misuse. So it has to be litigation that's currently happening or litigation likely to be filed. It's again wanting to help make sure that public bodies and agencies have the ability to kind of have, even footing if litigation is likely to be filed or currently being filed, to talk with their counsel a little more frankly to say, this is happening. What do you think we should do? That kind of thing. So, but just again, this is one we do recommend usually asking your legal counsel about first to make sure you are using it properly, because we have seen it misused. So, but yes, that one. Again, kind of another legal one, exempt public records. So you can go into executive session to consider information or records that are exempt by law from public inspection. So this one is both public meetings law and public records law. So you can only go into this executive session if you're considering a record that is exempt by public records law. But that would be like some documents that are attorney-client privilege. That would be something you could use for executive session. But just making sure that you are going to this, there has to be a document. You can't just say, oh, we want to go talk to our legal counsel, but it's not about current legislation, so we're going to use this one. There does have to be a document. But yes, just making sure that you are checking public records law for that it is exempt. But attorney-client privilege is a common one. There are some trade documents, a couple other ones, but probably attorney-client privilege, I think, is one of our most common ones.
They're listed in executive session, public meetings law, but there's some that are exempt all the way across the board. So, student records, as far as medical records.
Yeah, and those are also, we'll talk a little bit too, some of the media can be excluded from these when certain documents that are excluded from public record as well.
You always have to refer to public records law.
Yes, so those are something we may not be able to give advice on because that is outside of our jurisdiction. So just to be aware of.
Is there a source for us to look into, research on the website, or?
Yeah, so that AG manual actually goes over both public meetings law and public records law.
Thank you.
And it has a list of all the exempt public records. So again, that's probably one of my favorite resources for public meetings law. Look at it probably once a week, if not more. So, and so the new in 2023 and 2024, they did add some new security matters one. So the first one is to consider matters relating to the safety of the governing body and of public body staff and volunteers and the security of public body facilities and meeting spaces. So basically security related, making sure anything with your area, public body facilities, that kind of thing, you can go into executive session because obviously you don't want to talk about that in public. That makes sense. And the second one is to consider matters relating to cybersecurity infrastructure in response to cybersecurity threats. They recognize that as kind of something that's more common these days. So that is also something you can now go into an executive session to discuss. But so those are the most common ones we see with executive session. Again, this handout does have all of the ones listed. And if you do ever have questions, you can reach out to us and we can help with that by phone or email or in person. We are in Salem. It's a little bit of a drive. But now we can talk about media representation because, like I said, most of the time media is allowed to attend executive session. There are certain cases where they can't. So first off is labor negotiator. Second off is expulsion of an elementary or secondary school student. So if you're talking about that, media cannot attend. If you're talking about students' confidential medical records, and then when we're talking about that litigation, when we're talking about the litigation provision, excuse me, if media is party to the litigation or they work for the company that is party to the litigation, they can be excluded from that executive session. But these are going to be the only reasons you can exclude media. Otherwise, media is allowed into executive session. So,
I think you added, you do not want the media to report on anything.
Yes.
going on in executive session. To state that.
yes, that is, yeah, with that, and that script does have that there to remind you. Okay, so now we can do a knowledge check. We'll re-ask those questions and then we'll answer them together and kind of go over that too. So, first one. If the discussion topic meets the requirements for being discussed in executive session, the governing body cannot meet in open session to discuss the topic. A for true, B for false. Perfect. Yes, that is correct. Just because the provisions allow you to go into executive session does not mean you have to. You can choose to have an open meeting still. That is up to you. So if the public body will be discussing multiple topics in executive session, A, 192.660 needs to be cited. However, no specific reasons or statutes need to be announced. B, only one of the topics must be announced before entering executive session. C, all of the topics that will be discussed in executive session must be cited. Or D, topics only need to be cited in the public notice and do not need to be cited again before entering executive session. Yes, all of the topics that we discuss in executive session must be cited. Okay. A governing body can make final decisions in executive session. A for true, B for false.
I think we will change that.
Probably not a lot. These ones are pretty easy. Yeah. Okay, during a meeting, members of a governing body are individually and independently responsible for A, their actions, B, their non-actions, C, their actions and their non-actions, or D, nothing. The governing body is responsible. Perfect. Yes. Topics discussed in executive session must be expressly permitted by the statutory provisions and properly cited. The discussion may not cover other topics, even if those topics are related to the topic cited. A for true, B for false. Perfect. Yes, we need to make sure we stay on topic. All right, before a governing body may convene an executive session to consider the employment of a public officer, staff member, or individual agent, the following prerequisites must be met. So A, advertise the vacancy. B, adopt regular hiring procedures. C, provide an opportunity for public comment on the officer's employment. D, for chief executive officers, adopt hiring standards, criteria, and policy directives in meetings open to the public where the public can comment. E, all of the above, and F, none of the above. Yes, all of the above for that. Perfect. Okay, and then we'll talk a little bit because public meetings law. So we used to just have executive session provisions, and then September of 2023, we expanded to have all of public meetings law. And with that, they also updated the grievance process for that. So submitting a complaint, instead of just submitting a complaint now, there's a new process where if someone has a grievance with a public body, they have to submit a complaint to you first. You have to respond to them, or you have a chance to respond to them. You don't have to respond to them, but you have to give a chance to respond to them before they submit a complaint with us. So, but now they can file those complaints with us for all public meetings law, not just executive session, but there are those new requirements. So those prerequisites, they have to submit that written grievance to you, has to be submitted within 30 days of the alleged violation. And then you as a public body have 21 days to respond to them. Once that has been met, whether the public body responds or not, then they can finally submit the complaint with us. So after that 21 days period is over, they submit the complaint. They have to provide the copy of the grievance they sent to you and then provide your public body's response. We're going to talk about that. We prefer the public body just to also copy us when they send a response, whether if you email or mail it out to them, just also sending us a response makes it real easy in case they come back to us and say, hey, They never responded to us. And be like, oh, actually, they attached us on this email. They did respond. But so once you get that grievance, again, you'll have 21 days to respond to it. You have to acknowledge receipt of the grievance and send the written response to us at the same time. But in that response, you either have to admit the facts and deny the violation, or admit the facts and admit the violation. So denying means you're going to deny the facts, describe what the public body says happened, and explain why that's not a violation. 2, you can admit the facts, say, yeah, that's what happened, but actually that's not a violation because this is actually what public meetings law says and why that's not a violation. Or 3, going to admit the facts and admit the violation. Say, yes, that's what happened. Yes, that is a violation of public meetings law. This is what we're going to do to cure the mistake. So if that was a vote or something, that may mean you meet to redo the vote. If that's going to cost you money, or if there's a reason why you cannot meet to redo the vote, then maybe that's explaining that. But then saying what steps you'll take as the public body to make sure that doesn't happen in the future. So those are the three types of responses you're going to do when you respond to that grievance. And then from that, once you've responded to them, or those 21 days are up, whichever happens first, then they can make the complaint to us. Do you have a question before?
Yeah, so we only respond in CCU if it's an official complaint or all grievances.
All grievances about alleged public meeting violation.
Okay.
We are clarifying, that's part of the rules. This is one process that we're making sure we're clarifying the rules on. I would recommend probably looking at like our public meetings law page, and we can look at that. We'll talk about our resources and stuff because it's already started. You can look at a draft of the rules, talking about like having a dedicated person or having a dedicated email for this to make it easier, so they aren't submitting this and you're, submitting it to someone and then you're like, we never saw this, and then so things like that don't happen. But yes, any grievance submitted of a public meetings violation, you would have 21 days to respond to. So yes.
Are you familiar with any school districts that are successfully managing the complaint process through like an electronic submission? We have a tendency to have a regular a fair amount of complaints, and I was thinking about it the other day that this is not in an attempt to stop them, but to be more organized about them. And sometimes complaints come in with, a myriad of complaints, and it's easy to sort of get caught up in and miss something, or, not address an issue. Do you know if anybody's doing like a portal where because I like your idea about them going to one central location. But I'm just thinking of like a fillable form that it makes the person who's making the complaint easy to sort of input all the data, but then for us to receive it and make sure that we've got them all organized.
No, I don't know off the top of my head of any like specific school district or any specific program. I do know because I've been on a lot of our rulemaking calls and everything. They have asked specifically, some of our rule advisory committee have asked that the language about that includes that electronic submissions be included, because people are planning on using something like that. So I know people are planning on using it. What they're specifically using, I do not know. That might be something to reach out to like the OSBA, that they might have some resources on that, especially as.
Because that 21-day timeline is super short for, we meet once a month, and, it creates a bit of a hardship on the board to be able to convene and to gather the data and to review it. And it just feels like it's a pretty inefficient system that we have. And so I guess we'll be looking into that.
It's definitely tight, but I agree with you there. And unfortunately, that's how the statute is written. So like we can't do anything about it. I know I would definitely suggest, writing to your legislators and stuff like that, because that is something more lawmaking that would have to be done for that.
Well, I mean, we would just make sure we're following all of the rules. I just think that there's some mechanism by which the person who's making the complaint, it's an
Yeah.
easy process to prompt them.
Yeah, I do know
What
people
would
are
this
planning on
be?
using
What is
electronic
this?
submission because
What is
they
that? What
have,
is that?
at least on the Rules Advisory Committee, the people that have been talking have planned on using that because they were very specific in including that language. I just don't know what products or what platform they're using.
But we'd
for it.
also need a mechanism that if they're not making it an electronic, like if they don't have access to an electronic
Mhm.
system, that we've got.
It needs to still be accessible, so there needs to be other
Accessible,
options
yeah.
for them, yes.
I'm just
Mhm.
thinking about it from an organizational standpoint and that
Completely.
we're making sure we're hitting deadlines and we're fully looking at all of the issues identified. So thank you.
And
course.
to confirm, it is 21 days from the receipt of the complaint,
Correct.
which electronically, if we're receiving it via email,
Mhm.
is it 21 days from when that email is sent by the sender or when it is? I mean, I'm trying to imagine a scenario, if a complaint is sent directly to Dr. Radich, for example, and she doesn't get it or it doesn't get to us, like when is that actual start time?
It is currently written received. And as it's written, it would be received. This is kind of what we were talking about in rules because we wanted to make sure that it's not just being given to someone that
Right.
then isn't seen. But as it was written, if it's given to someone on the public body by that day, the day it was given, that's when the 21 days starts currently.
Well, and I'll just make this comment for the board. I think this goes back to our policy committee. I think we really need to look at our complaint process, make sure that we have all of the components to it, making sure that we're making the deadlines, and maybe that's the policy committee helps create a process that both meets the needs of the complainant, but also meets the needs of this body, and then for when they get referred to you guys and followed up.
Yeah.
Because we want to be able to do that, but whoever picked 21 days,
Yeah. Which also does, we are in the rulemaking process. We are going to be opening up for public comment soon. As it plans, I would check our website. We do have a couple scheduled dates. They're tentative right now, but that will be open likely for the month of August. So that is something if anyone willing, both public and it's open to everyone. So that month of August, it will be open and you can read both the draft. I think August 19th is our current scheduled date, again, tentative. So I would check our website. But that's definitely, we'll love to hear your comments because that is the time to make those and we can help clarify some of those things more if possible. So, Charlie, did you want to take over for the ending?
Yeah,
Okay, cool.
I'm the standing guy. All right, so we saw a little bit about this before, but complaints. So you folks already know that we do not take anonymous complaints. The complaints that we get must be signed. They do have to sign their name because guess what? When we get a complaint, if it's something that falls within our jurisdiction, we're going to be reaching out to those folks that filed the complaint. Okay. And they do go through a process. We do take a look at them. If it does look like there has been a violation, then we will, in our preliminary review, we will ask the commissioners if we can move forward with the investigation. So again, we don't make that determination. We always ask the commissioners, we found this, it looks like there's maybe been a violation. Can we get your permission to move forward? And so we get that from them.
Clarification. So that's not like a grievance or complaint to us. This is they're sending you a complaint about us or about a public entity. Okay. And so that has to be a physical with signed.
After the grievance process first. After that's done, then they can submit a complaint to us.
Okay. But it says signed. So it has to be physical then?
They can do it online and it's a digital signature. They can also mail something in and sign it as well.
Okay. So they can have a PDF and have a signature on it, send it that way. Okay. But they just can't type their name on the end of an email and that's not a signature.
They can do that as well.
Okay. Okay.
Online solution. So-
Oh, I see. Gotcha. Thank you.
All right. So if they are found in violation of ethics laws, then civil penalty of $1,000 max. Letters of education. This is for public meetings law violation, so a little bit different. So civil penalty of $1,000. There is a letter of education and then possible training requirements. So, like I said before, in the past training, is that a lot of folks realize that they made a mistake, or they didn't realize they made a mistake until a complaint was made. And so that's usually where the letters of education come in. or the training. So, but you know this already as well. You can always reach out to us for advice. So do take advantage of this. A lot of folks do. With the advice that you ask for and that we give to you, you follow it. It does give you a level of safe harbor. Okay. So staff advice comes in different forms. Yeah, you can take the training like you're doing today. That's the first step. Staff advice, that's where me or Lex would write something up for you. Of course, everything goes through our director. So it's not like we're writing something up and sending it off and then hoping that, we don't hear from you guys again. Everything goes to our director. She looks at it and says, okay, or no, that's not quite, you missed the mark. But staff advice or staff opinions, that's where our executive director comes in and actually will give you more of a formal, a more formal form of advice. And then there's actually ones where they actually ask the commission for that advice. And so you probably already know our commissioners are all lawyers. So that's when you're getting the big one. But usually the last step we get is staff advice. I mean, this is where a public official just asks us, hey, I received this thing, or I have this conflict of interest. How do I handle it? Typically when lawyers get involved, that's when we start getting into staff opinions and commission opinions. And you already know there's a website with all our stuff on it. When you first take a look at it, it looks pretty complicated. But when you start to dissect it a little bit, you'll start seeing that there's public records. You can look up past complaints, past advice we've given. Last session, we talked about SEIs. You can go in there and look at public officials, what they've filed for their SEIs in the past. This is for everyone, every public official that's required to file an SEI, they're in there. Also goes into public meetings law. That's a good one to hang on to when it comes to public meetings. I believe that a lot of folks are on a list for when public meetings law trainings are available. Everyone will be getting the email saying we are now offering these trainings. I think we're going to roll out online trainings first before we get into in-person trainings. So that'll make it a lot easier because it is going to be required for a lot of folks. So you want to make sure that you're on the front end of that and not on the back end of it. So, and of course, you already know if you're curious and you're wondering, hey, I didn't get the email or I didn't get the notification where we at, call us, shoot us an email. We'll let you know. If you're not on that list, we'll verify it and we'll put you on that list. And of course, training, we ended up here because of, I don't know who reached out to us, but if you want other folks, staff to take some training, we can do that as well. A little bit easier. You can either have us in person again, or they can sign up for one of the webinars that we do all the webinars every month. So, and we try to rotate them where if we did one on Tuesday and have the staff is off on Tuesday, then the next month we'll be doing it on Wednesday. And if we did one in the morning, then the next month it'll be in the afternoon. So that's kind of how we keep that rotation going. And then of course, advice is on there and complaints as well. And so last part of this is how do you reach us? So our general mailbox is mail at OGEC. We always call it OGEC, but OGEC@.oregon.gov. You can call us. We're a small staff, as much as you may think that there's hundreds of people at the Ethics Commission. It's not, it's like 15 of us. So we take pride in answering the phones. So give us a call. That's our website. I'm Charlie, that's Lex. You heard me say this last time, but we really, really, really appreciate your feedback. So just shoot us an email. If you've been in correspondence through emails with us, there's a customer survey in there, but just let us know how the training's going. Okay. Typically we do a training. We tell people, let us know how we did. We get back and we don't hear anything. So we're like, I guess we did okay. No complaints. So, but if we're doing a good job, let us know. If you think we can do a better job, let us know. Okay. If you think it was absolutely horrible and we need to start over, let us know.
Who was your counterpart last meeting?
Last meeting was Ruth.
Ruth. Okay.
And that's all we have for you. Again, thank you for having us come out here and do this for y'all.
I have a question.
Yeah, go ahead.
It appears I'm unaware of any remedy for when somebody violates the confidentiality of executive session. Are you aware of anything?
So there's nothing in the statutes within our jurisdiction within the statute. No, you would have to probably talk to legal counsel and see something like an introduction would be the best. way to go about that.
Thank you. I appreciate you guys coming out. I know it's hard to get out of the office sometimes, but to have you guys in person has been really great. Yeah.
In person, the impact's bigger, and it's also just known that when you're dealing with a city or a school district, it's gonna be in the afternoon.
Yeah.
That's
Yeah.
just,
Of course.
but that's all we have.
Thank you very much.
Thank
Very
you.
Appreciate it.
I thank you, of course, but I actually, can we deliberate a little bit more on the scenario? You started going down the path earlier and about, we're talking about the building, then all of a sudden we want a maintenance building, but the stated was a building.
Yes.
Okay, and now in these executive session, two C's, I's, J's, M's, whatever, and also what's on the agenda is just listed with that, with the suggested verbiage behind it. But I don't know that we're talking about the building.
Okay.
So when
About this before.
I think so. I think last week I hinted at it. So when should that be stated? Or does it need to be stated publicly or it is not, is at least stated, you know, when we get in there, like they open up this executive session, like, okay, 2B relates to Joe,
Yes.
2F relates to X. Okay. Just whatever your best suggestion is, or maybe I hit it, but I don't know.
Go ahead.
Okay, so yeah, so when you're saying in public session that you're going into executive session to discuss things, you don't have to be super detailed, because obviously you're going into executive session to have a private conversation. You do need to give some general idea of, we're going in to discuss the 192.660 subsection 2 subsection B to consider the dismissal or disciplining of an employee, right? That's all you have to say.
And we have that. So.
Yeah, right. And so then at the beginning of executive session, we would say, okay, we're going to discuss this one to talk about the disciplining of this employee's name. So that's when you would go into that to give that more specific example. So then you know, okay, we are only talking about this employee Joe, right? So if it ever starts to veer off into employee Jan, right, then you know, okay, we have exceeded the scope. We're no longer talking about this. We need to go off. So does that kind of?
That is exactly what I wanted to know. So thank you. Other than that, that's all I have. So appreciate it.
That was the example I was gonna use. You're talking about an individual. You can't talk about, well, John does the same thing all the time.
Yeah.
Let's talk about John now, because you know, he's just, no, John isn't part of this conversation. We're talking about Joe.
Yeah, I think it's best at the beginning when you start that topic to say this is the specific thing we're talking about, so then you can very much know these are the parameters, and then if you go off of it, to be aware of that, so.
Oh, one last question. As somebody that's on the leadership team, how do I just do a normal request to say I want to talk about some executive session? Or can I at least bring that up at the end of one executive session for the next time? Hey, I would like to bring this up on our next session. Is there any suggestions on how to do that or recommendations?
What, just talking about discussing going into executive session about a future topic, or?
Yeah, it's a future topic that I want to, we didn't talk about XYZ today, but next time we have executive session, I would like to talk about XYZ, which I know from going through this or just now doing this for over a year now, I know that's an executive session topic and not an open meeting topic. So how that's somebody that's not either the superintendent or the leadership team, like how do we request? And is that just, should I just shoot an email, or is that, can I mention that at the end of one executive session to talk about next executive session? Is that okay, I guess, is what I'm trying to say?
Still have to announce it because it's part of that public announcement that you're going into executive session. Or going.
It'll be for the next session, but I'm talking about like,
Exactly.
okay, just your example. We talked about Joe, but John's doing the same thing. So, hey, can I say next meeting, can we talk about John in the executive session? We're not talking about him anymore. I want us to say, I want to announce, I want to talk about John next session. And
But because it's an executive session topic, I think we might need to follow up on that one.
Okay.
Because I know how we do it, but because we're the commission, we have some different statutory obligations,
Sure.
so I'm not sure how it.
And I wonder if it's a conversation with the chair or the vice chair or the
Well, that-
superintendent, and say
Yeah,
out of that meeting and say,
you just right off the top, I would think that it's anything that you'd be discussing in executive session, however you came to that point where we're going to discuss the executive session, that would be part of that too. So if you folks were saying, hey, we're gonna talk about this land, that we're gonna be purchasing and we need to go in executive session, you're talking about where do I make that announcement that this is gonna be part of the next executive session?
No, like planning the next, like, okay, so this is our next agenda, like, I know on this next agenda, or planning this next meeting, this is what needs to go on the next agenda. Which is where I'm thinking it's more of a planning thing, so.
And I think, can we just say that this did actually come up, but it was a similar topic, just like you said about Joe and Jan or whatever.
Yeah.
And
Which partially makes.
I
it
s-
a procedural.
I said, I don't think we're cited properly to have that conversation, which I felt a little bad about, but I felt nervous about moving on. And so, but I think that's a conversation that
Yeah.
then we could have, you and I we could talk about it, and then I could work with,
Let's
The
do this,
superintendent.
'cause we want to get you a good answer.
yeah.
I hate to bounce it around and get kind of a wishy-washy.
Yeah,
like,
no.
I think that's how it's done. Let's get back to our director and pin that down for you folks.
That'd be great.
Okay.
So that way-
Thank you.
That way you can look at it and go, okay, this is how we handle this.
Good.
There's no question.
Just
Yeah.
historically, generally, if a board member wants that, they are in contact with board leadership and the superintendent, then it's scheduled. Sometimes there has to be research before the executive session as well. So there's obviously some planning. If somebody wants a certain topic, sometimes we need some time to get the research ready. So when we have that discussion in executive session, there's something to talk about.
Yeah, I get that. I was just, that's fine. I think we're all in alignment, at least how we may handle going forward, but I just wanted to know if there's any direction.
Public body decide, and we don't really have jurisdiction over, but we will verify that, get back with you to be.
Thank you.
100% sure. So. All right,
Thank you.
yeah, thank you so much.
Yeah, thank you, and safe travels back. Okay, so we will go back up to our action item under declare surplus Tiger manufacturing equipment per board policy DND1. Now that we have, do we still have Nancy on? Okay. so we-
Yes, I'm still on.
Thank you.
Yes.
Okay, Dr. Radich.
Thank you. Max Davidson, who works with ARD Manufacturing and Tiger Manufacturing, had submitted a list that you can see in your packet of surplus equipment that would require board approval to declare surplus prior to any potential sale or disposal.
Do we know, I thought we approved a list 3 or 4 months ago. Do we know this is a different list? Is there new things added? I mean, is this just a revised, updated?
My understanding is that the date on this was July 3rd. And when I received the email from this gentleman, he indicated that this needed to go before the board. So my assumption is it's new, but I could be wrong. But the date is clearly this month's date.
Okay.
And we did do a surplus.
There's been
but I
several
don't think
surpluses.
that was the big one. Like, I felt like we had a big one like this.
I thought we had a Tiger manufacturing one as well. Once they knew what they had in the new, once the building was up and running for a while, then they're like, okay, we know what we need, what we don't need. And I also thought then there was also another list. We've had a couple different lists being approved over this last year. So
Yeah, there should be a fairly substantial list from the school district, but I'd have to go back in the archives and find that. Not specifically Tiger Manufacturing,
Sure.
but district surplus.
okay.
I wonder if this is an additional, like now they've discovered that they have all this other stuff.
The sense I had that it was something they wanted us, the board, to take action on now so they could take care of it.
Do these surplus lists, assuming that we approve it, do we ever get a follow-up report on those? Is that something we're privy to? On what?
I can certainly ask, yes.
I mean, I understand the bandwidth that it would take, but if it is a standard report that they submit, I would love to see that.
I don't know if there's a standard, but certainly we can ask for one.
Yeah, I don't think we've seen any report that follows up and says, oh, hey, we were able to sell various turning tool insert holders for $50 versus the 20. Be interesting to know how much they must obviously give it through to accounting to account for the sale of that. So,
And normally it does go back into the program.
yeah.
That's normally how it's managed.
Yeah, this certainly seems like a comprehensive list of some big things and some very small things, and I just appreciate the work of Tiger Manufacturing and the hours that probably went into this. So I'd like to say thank you to the team for that.
The one at $2,000 for the clausing lathe and
Yeah, big stuff, but
CNC mill. Yeah, I have no idea what any of these things are, so. Do we have a motion?
yes. I move that the Newburgh Dundee School District Board of Directors declare the attached list of Tiger Manufacturing equipment and materials as surplus and therefore eligible for sale per board policy DND1.
Do we have a second?
Second.
Any discussion? Okay, then I'll call for the vote. All in favor of the motion, please state. your-
Aye.
Okay, so we have Nancy Woodward as an aye
Aubrey Nichols, aye.
Jeremy, aye.
and Deb Bridges aye. So the motion passed
4-0.
4-0. Yeah. Okay, thank you, Paula. So we aren't able to convene our executive session until just before 8. So it seems like we should take a break from this meeting, read the executive session post, but we can't, the people that we need to have on the call are not available until 8. I guess we could
Right,
start
we have some other
the
items. we
other
could-
items.
if the
Okay.
board chooses, I would have to get my computer. We have to set up for that other for the executive session anyway, for the different link.
Mm-hmm.
So if the board is interested in taking a short break, then I can at least get the help, and they'll have Nathan help us get linked up, and those individuals won't be joining us till 8, but we can at least get some of the
Okay,
other work
so
done.
could I read the executive session portion? Okay, so we will be going into executive session. And there's some adjustments to the reasons. We will not be going under the ORS 1926602B, which is to consider the dismissal or discipline of, or to hear complaints or charges brought against a public officer, employee, staff member, or individual agent who does not request an open hearing. We will be going under ORS 1926602D to conduct deliberations with persons designated by the governing body to carry on labor negotiations. And ORS 1926602E to conduct deliberations with persons designated by the governing body to negotiate real property transactions. ORS 1926602F to consider records exempt by law from public inspection. And ORS 1926602H to consult with legal counsel regarding the legal rights and duties of the public body with regard to current litigation or likely to be filed. Representatives of the news media and designated staff shall be allowed to attend the executive session. We will hold our executive session in this room. Representatives of the news media are specifically directed not to report on or otherwise disclose any of the deliberations or anything said about these subjects during the executive session, except to state the general subject of the session as previously announced. No decisions may be made in executive session. At the end of the executive session, we will return to open session. So at this time, we will be taking a break. and we'll reconvene when we're finished with our executive session. Okay, we are reconvening the Newburgh Dundee Public School Board meeting for July 24th. We've just exited executive session and now we are adjourning our meeting for this evening. Thank you, everyone, for attending and tuning in. Good night.